May I proceed?
You may.
Good morning, Dr. Solo. Could you please introduce yourself to the court and spell your last name for the record?
Yes, my name is Dr. Campbell Solo. Solo is spelled S-O-L-O.
Why are you here today, Dr. Solo?
Today I was retained by the plaintiff to answer 3 questions. The first being if Jesse Duran posed a significant danger with firearms. The second being if these symptoms were present before August 18th, 2010. And the third being if Hayden Duran was aware of these symptoms.
What qualifications or education would you have to answer those questions?
I received my bachelor's degree of psychology from the University of Oregon, as well as my MD from the University of Michigan. I am licensed to practice in both Wisconsin and Midlands, and I am currently the sole owner of Solo & Associates.
Now, prior to your testimony in today's case, did you review any materials in coming to your conclusions?
Yes, I did. I reviewed and analyzed the affidavits of Danny Brooks, the babysitter of Sydney Park, as well as the affidavit of Andy Park, the mother of Sydney Park, and the affidavit of Hayden Duran, the mother of Jesse Duran, as well as certain exhibits, those being a drawing by Jesse Duran, a disciplinary notice from Jesse Duran's school, and an email written by Hayden Duran to her friend Casey French.
Did you rely on any principles or methods you might have acquired from your education in coming to your conclusions?
Yes, I relied on the principles of environmental psychology.
What is environmental psychology?
Well, environmental psychology involves analyzing a child, in this case's environment, in search of factors that may have affected the child, and therefore, in turn, how that child affected their environment.
And how did you apply this principle of environmental psychology to the facts and data that you were given in preparation for today's case?
In analyzing the data I received, I found the circumstances of the environment which affected Jesse Duran, and therefore how she in turn affected her own environment.
Now, I want to talk to you a little bit about your conclusions. What was your first conclusion in today's case?
My first conclusion is that Jesse Duran did pose a significant danger with firearms.
And what led you to that conclusion?
In my investigation, I found that Jesse Duran had an overexposure to violent media through the video games that she was allowed to play.
And how did you know that Jessie had an overexposure to violent media?
It seemed as there were many instances and many accounts of her often playing video games that were very violent and involved guns.
And what kind
Objection, Your Honor, improper character evidence.
Okay, would you expand on that, sir?
Yes, Your Honor. They are using these instances to suggest that Jesse would act in such a way in the future as to recreate playing with these games.
Thank you. Your response to that, sir?
Your Honor, this is not being showed for action in conformity therewith, but rather knowledge on the part of Hayden Duran, that Hayden Duran should have been aware, which is our burden in today's case, that Hayden Duran should have been aware of the need to control their child. And if you look at the case law, the plaintiff may also prove that the defendant knew or should have known of the need to prevent the child from creating an unreasonable risk of bodily harm by showing that the defendant parent was told otherwise or received notice. Skoll v. Kitchener and Totten versus MAF both assert that the plaintiff is allowed to use past instances to show knowledge on behalf of the parent.
I'll respond to that point that counsel just brought my attention to. You may have a second if you wish. Go ahead. You may have a second.
Thank you, Your Honor.
No problem. And the Skoll case was another case?
Yes, the one right beneath that, Totten v. MAF.
I thought so. I just want to be sure. Thank you, counsel.
Your Honor, it is my firm belief that the opposing counsel is not using these to show knowledge, but to to establish that Jesse would act in the future in a way that the violence of these video games portrayed, not for showing the knowledge of Hayden Duran.
And the only way we're going to know that is allow the evidence to proceed. I previously taken any objection. For the record, I'm going to say that you withdrew that because that objection didn't go down that street. If you're asking me to monitor the testimony to make sure it does not vitiate these cases, I shall do so. In order to do that, I have to allow the inquiry to proceed, which I shall. At such a point in time, if you think we got to that precipice, please let me know. But right now, until we get there, I have to allow council to proceed. So I'm going to allow a continuing objection, so another objection, after objection, after objection. But if in your opinion you wish to renew that, then I'm going to allow you to do so, okay?
Yes, Your Honor.
Please proceed, sir. And thank you for the citation, thank you.
Again, what would the effect of this overexposure to violent media have on Jesse Duran?
As I said, a large amount of exposure to violent media affects a child's psychology and gives them a predisposition of violence.
Now, I want to talk to you about your second conclusion in today's case. What was that conclusion?
My second conclusion is that Jesse Duran portrayed these symptoms of violence before August 18th, 2010, the day of the incident.
And how did you arrive at that conclusion?
In my investigation, I received a drawing that Jesse Duran drew.
Would you recognize a copy of this drawing if I showed it to you today in court?
Yes, I will.
Your Honor, let the record reflect I am approaching opposing counsel with what has been marked as Plaintiff's Exhibit 2 for identification purposes.
The record should reflect that. You see that before council?
Yes, Your Honor.
Thank you
Let
very
the
much.
record reflect I am approaching the witness at the same time.
It shall.
Would the bench like a courtesy copy?
Just one. Thank you very much. Thank you.
Dr. Solo, what have I just handed you?
This is the drawing that I used in my investigation.
And who is the drawing by?
It is by Jesse Duran.
And how do you know it's by Jesse Duran?
The police obtained this from Jesse Duran's house during their investigation.
Your Honor, at this time, the plaintiff now moves Exhibit 2 into evidence.
Any objection, Counselor?
Yes, Your Honor. This evidence is substantially more prejudicial than it is probative.
How do you respond to that balancing?
Your Honor, there's nothing substantially more prejudicial in the fact of this drawing. This witness relied on this in coming to her conclusions, and there's nothing inherent in the actual document that would be far more prejudicial than it is probative. The probative value in that it also contributes to understanding this witness's testimony far outweighs any prejudicial effect.
In retort, do you have a brief reply to that, sir?
Yes, Your Honor. Nothing in this evidence proves anything in this case more likely than not to be true. Therefore, it is substantially more prejudicial than its probative value.
Your Honor, the opposing counsel said that it doesn't make anything more likely to be true. That would be a relevance issue. And a document showing whether or not this child is showing the child playing with guns in this case would be highly relevant. The fact that this has a probative value and that it allows the jury to understand how this witness came to her conclusions negates any prejudicial effect it might have.
Is not the standard the reverse, that the prejudice overcomes the probative value rather than the reverse of that?
Yeah, that's what opposing counsel suggests.
I want to make sure I understand the standard correctly. I think that I'm going to allow it in, but sir, I'm going to, since you open that door, I'm going to give you great latitude to go into all the factors you wish to do as an instrument, but because it was used as a pointless opinion, I have to let it in, but please be warned that there will be wide latitude if you wish to avail yourself of that to get into this, sir. Okay?
Yes, Your Honor.
So we'll be admitted, thank you. Go ahead.
Dr. Solo, would anything help you in explaining this document to the jury and how you use it in your conclusions?
Yes, I prepared a demonstrative in today's case.
Your Honor, may I set up the courtroom for use of the demonstrative?
You may, counsel, if you wish to position yourself so you can see what's being displayed, I will allow you to do so. Whatever your choice might be.
Yes, Your Honor.
Okay, thank you.
Your Honor, permission for the witness to step down and make use of the demonstrative?
Will it help the jury understand what's being displayed?
Yes, I believe she just testified.
I want to make sure the record's clear on that. Thank you. You may step down.
Now, Dr. Solo, what specifically about this drawing led you to your conclusion that before August 18th, 2010, Jesse showed signs and symptoms of violent tendencies?
Well, there are 3 boxes that are particularly troubling to me in this document. Those being the 2nd, the 5th, and the 6th box.
And what particular about those boxes led you to your conclusion?
Well, in the 2nd box, it shows Jesse Duran pointing a gun at her television with playing video games. Again, this goes into what I had said previously, how video games had a large effect on her and her environment. The 5th box is the most troubling. shows Jesse Duran pointing a gun at other children, which is always cause for concern. And then this sixth box is also troubling because it says, "I heart my gun," which I believe to mean that she loves her gun.
And what did this mean for you?
This meant that she had an attachment to firearms and a fascination with them.
Your Honor, permission for the witness to retake her seat.
Absolutely. So please do so.
Your Honor, permission to approach and tender the authenticated copy of this document.
If you wish to do so. Thank you very much. Thank you. Counsel.
Dr. Solo, what was your third conclusion today?
Can you see the witness? We can move
Yes,
that, if that's in this position where you can't see the witness. Thank you,
Yes, ma'am.
Counselor. Thank you. Please proceed.
Dr. Solo, what was your third conclusion in today's case?
My third conclusion is that Hayden Duran was aware of the violent tendencies of Jesse Duran before August 18th, 2010.
What led you to that conclusion?
In my investigation, I also received an email written by Hayden Duran herself.
And would you recognize a copy of this email if I showed it to you today in court?
Yes, I would.
Let the record reflect I'm approaching opposing counsel with what has been marked as plaintiff's exhibit 3 for identification purposes only.
It shall be done. You see that? Counselor?
Yes, Your Honor.
Thank you very much.
Let the record reflect I am approaching the witness with the same document.
Shall be done. Thank
The
you.
bench like a courtesy copy.
Warning, please. Thank you very much. Appreciate it.
Dr. Solo, do you recognize what I've just handed you?
Yes, this is the email that I received in my investigation.
Who's the email from?
It is written by Hayden Duran.
And how do you know that?
It is marked at the top as from Hayden and then proceeds to have Hayden Duran's email address.
Your Honor, at this time, the plaintiff now moves exhibit 3 against evidence.
Any objection?
Yes, Your Honor, hearsay. This
Okay.
is a statement used out of court for asserting the truth of the matter. It is therefore inadmissible here in court today.
What's your response, Counselor?
Your Honor, this is not hearsay since it's a admission by a party opponent. In today's case, this email was written by Hayden Duran, which is the party opponent of the plaintiff in today's case, and it is therefore not hearsay.
What's your response to that exception, sir?
None, Your Honor.
No objection. So I understand then you're withdrawing your objection?
Yes, Your Honor.
Thank you very much. I want to make sure the record's clear. And while we're on that train, there was continuing objection to the other matter. Likewise, I'm going to deem that to be withdrawn, so I want to make sure the record's clear as to each ruling. Thank you. Please proceed.
Now, Dr. Solo, what in particular about this document led you to the conclusion that Hayden Duran was aware of Jesse's tendencies before August 18th?
Well, at the start of the third paragraph, it starts by saying, "I'm a little worried about Jesse." This shows that Hayden Duran did express worry towards her daughter's behaviors. And then later in the third paragraph, it's Hayden Duran expresses that she had been hearing from other parents that Jesse was saying things to kids like, "Bang, you're dead." Again, very troubling and of Jesse's behavior, and again, proof that Hayden knew about this. And this document is dated July 1st, 2010, which is a month before the incident in question.
Permission to approach the witness and tender the authenticated document?
That'd be fine, sir.
Now, Dr. Solo, what was your ultimate conclusion in today's case?
My ultimate conclusion is that Jesse Duran posed a significant danger with firearms, both before and on the day of August 18th, 2010, and that Hayden Duran was aware of these symptoms and should have taken her daughter to counseling for these issues.
Thank you, Your Honor. No further questions at this time.
Thank you.